court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail bond on the two review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption of administration of justice.
Any objection, Mr. Ionetti?
No,
Yes,
Mr.
ma'am.
Chairman.
I would like to speak. I would like to
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Yeah, Mr. Evans, I indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appear, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for you, for your insight, as well as attention.
Clip 1. The hearing begins with the defendant announcing he wants to fire his lawyer, only for the judge to remind him, again, that he technically doesn't even have one, because he insisted on representing himself. The standby lawyer, the one he now wants replaced, hasn't even been acting as his attorney. Immediately, he begins shifting identities, calling himself an Aboriginal Native American Moroccan Royal Tribal Chieftain Squire, and already the court knows what kind of day this will be. The prosecutor calmly lays out the reality. 6 cases, 17 past failures to appear, and 1 active warrant out of Tacoma. The city calls him a high risk to ignore court orders, because he always does. But he insists this time is different. This time he really promises he'll show up because he desperately needs to hand-deliver a mysterious letter that he claims is so important it must reach the judge personally and be forwarded to Chief Justice Roberts of the U.S. Supreme Court. He argues he's being mistreated in jail, kept in 23-hour lockdown with a leg injury, but nothing he says moves the judge. Bail stays at $500 per case, because he simply can.
It is your duty to keep your address updated. I think $500 each case is very reasonable. To
I
ensure
can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there, because I want to prove that I'm innocent of these charges, and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg, and it's messing with the muscles and nerves because I need to keep my leg active and in motion, and they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Ionati while you're in custody so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole point I was trying to make. Mr. Ionetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many.
Desperate to get out on bond, he insists that the past 17 times H.E. skipped court were accidents, misunderstandings, or situations beyond his control. He tells the judge that he will absolutely show up if she releases him because he needs her to physically receive evidence that supposedly exonerates him. He even claims he's staying in jail under inhumane conditions, saying the kiosk doesn't work, the law library is unavailable, and his broken leg is deteriorating because he's stuck on crutches in solitaire-like conditions. When the judge points out that jail is not meant to be pleasant, he pivots, trying a new strategy, telling her she previously allowed him to travel through the airport, which is where his trespass charges came from, something the judge firmly denies. His arguments grow increasingly tangled, and despite all the drama, the judge remains unmoved. The bail stands, and the court will revisit everything on Thursday.
I'm in a
Mr. Ionati, when would you like to set this over till?
Thursday.
Right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ionati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionetti get me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes.
Well, you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Ionetti this, he never made any motions to get the process started. That's why
there is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself. And
that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll
It's
accept it.
gonna, it's gonna be extremely difficult to do that with the circumstances I'm in.
I can give you the information and go over.
Knowing his request for a PR bond has failed, he now switches tactics and tries to argue about his right to represent himself. He insists he wants to proceed pro se because the standby lawyer never filed motions he thought were necessary. The judge explains, again, that speedy trial timelines automatically begin at arraignment and cannot be manipulated the way he thinks. She reminds him that representing yourself in custody is extremely difficult, especially considering he says he has no access to basic supplies. But he keeps insisting he needs to file evidence under seal because the information he holds may endanger innocent lives. When she presses him to explain why nothing can be shared publicly, he spirals into vague references about federal matters, special evidence, and Supreme Court involvement. The judge patiently explains that none of this is a legal basis for bail, nor does it alter jurisdiction. And she ends the hearing by setting the next court date.
We disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out on.
Said?
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affected my leg. I broke my tibia and fibula in 5-6 different places, and the muscles and the nerves in my leg are.
At the next hearing, his standby lawyer informs the court that the defendant wants to represent himself, but still wants the lawyer on standby to help navigate things he cannot realistically manage alone from jail. He also wants to address his jail conditions. And of course, he wants his PR bond again. The judge asks whether he understands what he's asking, but he immediately launches into his identity again, declaring that he invoked his right as an Aboriginal Native American Indian chief, claiming this grants him special constitutional protections and immunity as a sovereign. He says his leg is still injured, that he's on lockdown, and that he mailed the judge a proof-filled letter that should grant him release. The judge asks if he has a legal change in circumstances, and he says yes, the fact that he sent the letter, since the court never received it. The judge tells him nothing has changed. He tries to redirect the conversation by saying the evidence proves he's innocent and the charges lack proof, but none of this meets the legal standard. Bail remains unchanged.
Mr. Does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fight history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport We have 4 pre-trials and 2 reviews involving those allegations, the same
And
allegation
in
before the
addition to
court
that,
today. Has warrant failure to appear stream pretty much every case.
What is his
that he-
date of birth? I'm trying to find him on Jabs.
my last name is Evans, it's not Williams.
It
sorry.
is 6/7/84.
And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday
And I-
as well.
And also, I never invoked my right as a Native American Indian chief. This time I did, so therefore I will not miss not one court date, I assure you. Can you
I'm
please?
not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before.
When the judge asked for his identifying information, he complained she got his last name wrong, yet immediately returns to arguing about the trespass charges. He claims there is no evidence against him because every time he was at the airport, it was for valid personal travel, even though his charges come from repeatedly entering restricted areas. The judge tries to bring the hearing back to order, explaining his history of warrants and noncompliance. He insists he has never invoked his Native American chief identity before, so this time it should matter and somehow guarantee that he never misses court again. The judge asks him how that changes anything, and he launches into an explanation that because he represents a sovereign nation, the United States has jurisdiction instead of Washington State, implying that the case must go to federal court or even the Supreme Court. The judge remains composed and reminds him that the state of Washington is indeed part of the United States, and his argument makes no legal sense.
Prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we
Better.
will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter gets sealed due to the protection of innocent life. not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence.
The prosecutor outlines again that he has a long history of failures to appear, including the active warrant from Tacoma, and that he keeps returning to the airport despite court orders. The judge notes that in nearly every case he has ends with a warrant because he simply doesn't show up. When asked his day of birth, he interrupts to complain that he wasn't trespassing and that his charges lack evidence. Then he circles back to the letter he claims he mailed, again insisting it proves his status as a tribal chief and that his cases must be transferred to federal jurisdiction. The judge restates that the court has seen no evidence of any tribal affiliation, especially since he refuses to name the tribe or submit any actual documentation. He tries to explain that he provided proof in a sealed case only he can access, which the judge obviously cannot accept as evidence. The judge reiterates, nothing he has said constitutes a change of circumstances.
Since you are acting as your own attorney, that if they do not receive the information that you've provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All right.
The city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if we're setting it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
No, we are not ready to address that today. So we will
Okay.
Address these matters